I would just add, Your Honor, if the court refuses to set a bond, requesting us disposition within 20 days of their on the MTRPs.
So here's what I'm gonna do, Mr. Branch. So the underlying offense that you're on probation for is a robbery and an assault on a peace officer, and the robbery occurred at Delaware Food Mart. Went in, attempting to steal, assaulted the clerk, and then they held you there while the police got there. And here we are 2 months after you got placed on probation, or 3 months after you got placed on probation for a robbery of a store. And we've got two additional robberies of the same store 3 days apart that are alleged. So obviously I agree with Mr. Smith. I think that you are a danger to our society. I am going to set bond.
It may be one of those.
So, Mr. Smith, on Jeremiah Branch, I have a new offense of 26 DCCR 1168. Is there something else coming, or is that?
I think that was the new one, Judge.
Okay, I thought there may be two. I may just.
So you're Jeremiah Branch?
Well, there's 26 DCCR 0958 and 26 DCCR 1168, the two new cases.
I've got Mr. Kimler on one of those new cases, but not the Mr. Kimler.
Not the latest.
Yeah, I don't have.
1168 is the latest one.
Yeah.
He was also indicted 3 weeks before that on a aggravated robbery.
1168 is what I don't have.
Yes, I have the indictment.
That's the one I'm.
I'll
He's taking no funding. I'm sure.
Okay, thank you. All right. So if you'll get a notice filed on that, Mr. Branch is charged with aggravated robbery, assault on a peace officer, robbery, and then the last one is another robbery allegation. What is the announcement?
He has a bond, I suppose. There's an MTRP.
Have you filed a motion for a bond, or what do you?
We're asking for a bond on the MTRP. MTRPs.
Did she print out the orders on those? Is that this?
Yes, ma'am.
Okay. So clause number is 25 DCCR 1382, which is an assault on a peace officer, and 25 DCCR 1385, which is a robbery, are both motion to revoke probations. And there are no bonds currently set. Is that correct in those cases? And Mr. Kimler has filed a request that I set a bond in each of those cases. It's like there's been a first amended filed in each of these. So he was placed on probation February 3rd of 2026. In both cases is 10-year deferred probations. And the allegations are a new aggravated robbery from April of 2026. Testing positive for cocaine on several occasions. Failing to submit to drug or alcohol screening on several occasions. Failed to comply with Texas Drug Education Program. A new offense of evading arrest or detention from February 6th. Resisting arrest or transportation, February 6th. And so, Mr. Kimler, you may proceed.
Well, Your Honor, they're deferred adjudicated probations. We would just request regional MTRP bonds. If the bonds are denied, we would request a disposition on the MTRPs within 20 days and request for the bond pursuant to the code of criminal procedure.
Is there any evidence with regard to your client's ability to make a bond, or?
Well, Your Honor, I think he's entitled to a bond. I haven't filed a writ to challenge the amount of the bond because it hasn't been set yet. So I'll wait for the court to set the bond. If that's excessive, then I would follow.
If I'm going to set a bond, I need to have information on what his ability is so that I don't set one and then we're back in here.
I could elicit that.
Raise your right hand the best you can, please, sir. You swear from the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
All right, go ahead.
Mr. Branch, please inform the court of your current financial situation.
I get $1,000 every month. and disability.
And other than that, do you have any
I
income?
have food stamps. And I was gonna look for a part-time job too.
What is your disability that prevents you from working?
Seizures, but they told me I could work like I could work like 3 to 4 hours a day.
Go supplement your,
Yeah.
do you have any assets? You own your own car?
I you know I don't own my own cars.
Uh, are you,
My mom gave me my mom not able to give me a ride.
are they giving you medication at the jail?
Yeah, they just put me on the new medicine and it's been working good with everybody on the dorm say I haven't been having seizures or outbursts.
What medication are you on?
I've been trying to get the name of it, but I tried to ask my nurse the name of it this morning, but I was a little sleepy.
Are you functioning okay now?
Yeah, I'm functioning way better now. I haven't, but when I got here, when I first booked me in, I had like they definitely in the booking was on the booking, the front booking for like 4 days, and I had like 5 seats there.
If the judge grants you a bond and you're able to get out, would you follow up maybe as a condition of your probation or a condition of your bond with MHMR
Yes, sir.
to continue the treatment?
Yes, sir.
And as far as your other financial assets, you don't own your own car, do you rent, or where do you live?
I stay with my mom.
And your monthly expenses about what are these? As far as food,
She pays the bill, and I'm on food stamp.
password.
No questions, Judge.
Okay, so for the record, I'm taking judicial notice of the court's files in all of the cases. And so give me just a second that I'm right now going over the probable cause affidavits and those 2 new offenses. Then I'm gonna need something else as well. Any witnesses, Mr. Smith, or just argument?
Just argument.
All right, give me just a second then.
Oh, we do.
Yes, sir. Yes, ma'am.
Almost there. Give me just.
Mr. Smith.
Also reviewing the precinct report from the 2 cases where he was placed on probation as well. In January of this year. So there was already information when he was placed on probation in January with regard to some mental health issues, and that was addressed. So he was placed on the mental health caseload. So it looks like that's not a new information that he had some. Okay, Mr. Smith.
Judge, I understand that these are deferred cases, but the state is opposed to setting bond based on the nature of the crimes that he was on probation for and the nature of the crimes that he committed within 2 months of being placed on probation for these first robberies. He, on top of the 2 felonies that are filed, there's also evading and resisting that are pending in misdemeanor court. He has failed several drug tests. He's refused to take other drug tests, indicating to me that he is probably under the influence of illegal narcotics most of the time. And for those reasons, I believe he is a danger to our community and I would request no bond in these cases.
I would just add, Your Honor, if the court refuses to set a bond, requesting us disposition within 20 days of their on the MTRPs.
So here's what I'm gonna do, Mr. Branch. So the underlying offense that you're on probation for is a robbery and an assault on a peace officer, and the robbery occurred at Delaware Food Mart, went in, attempting to steal, assaulted the clerk, and then they held you there while the police got there. And here we are 2 months after you got placed on probation, or 3 months after you got placed on probation for a robbery of a store. And we've got 2 additional robberies of the same store 3 days apart that are alleged. So obviously I agree with Mr. Smith. I think that you are a danger to our society. I am going to set bonds. I'm going to set bonds in each of your cases at $300,000. Conditions of those bonds, if you make them, are that you are on house arrest with a GPS monitoring device, and then we'll set your case for the appropriate hearing. Right?
Thank you.
Thank you. You are Ebony Broussard?
Correct.
And
Yes.
this is cause numbers 19-32518, 19-32806, and 21-36615. Ms. Broussard is on probation in the 32518 and 32806, was put on probation January 21st of 2020. 10-year deferred probations. One was escape while arrested, and the other was the second-degree assault on a peace officer. And then was placed on probation July 12th of 2021 in the clause number 21-36615 for a 5-year deferred probation for a state jail felony offense of possession of a controlled substance. She was here previously, entered pleas of true to counts 1 through 5 in that motion to revoke in each of the cases. There was no agreement. I received the pre-sentence report update. Have y'all both had an opportunity to review that update?
I have, Judge.
Are there any additions or corrections or anything on that?
Judge, I have just a quick comment. I'd also like to ask Ms. Richard or Ms. Fenton if they have anything for the court. They've been very involved in this case.
Anything that's not in the report that you think is important?
No, Your Honor, everything that we have in there is very direct in support.
All right, thank you.
And my only position, Judge, would be that she's obviously been extended almost every opportunity that probation has, every class, every structure, every program, and it would not be the position of the state like it typically is to argue for safety. In fact, I would argue strongly against it.
All right, Mr. Kimler.
I suppose, Your Honor, in response to that, she has demonstrated an ability to complete the programs, which is reflected in the pre-sentence report that she has been ordered to attend. Of course, there is a pattern of conduct that reflects addiction and substance abuse, but she also has the ability to complete the programs as well. I don't know how that relates to her inability, I suppose, to cope with the substance abuse issues, but she does have the ability at least to have enough structure and conform to the structure of these programs to complete them. So that says something. It looks from the pre-sentence report, it would be asking a lot to continue her on probation, especially with probation probably being unwilling to, or at least reticent to do that. I would only ask the court, if the court is considering the revoker, to consider something at the lower end. She does have children. And I'm not trying to use that as an excuse or anything, but they could maybe perhaps.
Children she was on her way to get while she was under the influence of PCP.
I don't know that they established conclusively that she was under the influence. I mean, again, it reflects the substance abuse problem, but she
She
does.
played true to all of the counts.
But yeah, that's true, Your Honor, and it reflects a continued struggle with substance abuse.
Yeah.
And so the issue then is going to be probably, I'm looking probably incarceration, but I would just ask that it be something not extreme, or at the upper end. And she wanted to address the court. What do you have to say?
I do take accountability for my actions, but however, I have completed ISL before.
And if you would be willing to work with me again, I would appreciate it. I have, before was incarcerated, I did enroll myself in outpatient classes, which was referred to me through Ozark when I went got assessed. And I was taking AA classes as well. I did complete 5 of the classes, however, I wasn't able to complete it because I was incarcerated. I do still have my job, and I did complete my 5-year probation for the first conviction. And I do pay my.
So is the
fees.
time, it was told, I mean, because of the
Should've been told.
motion. So yeah, I mean, you did the 5 years, but
Yes,
it's
ma'am.
not over.
Yes, ma'am. I
still-
understand.
What is, Ms. Malfino, do you have any position with regard to specifically punishment on these cases?
Sorry, Judge, I was just looking back at the original
Yeah.
PSI.
You have,
I do, thanks. Obviously, the court sees that she doesn't prior to this have any type of felony conviction, Judge, so I'll defer to whatever you think is appropriate, just in the context that they have given her so much of their efforts.
so, Ms. Broussard, you've been given the opportunity of, looks like you went to Franklin North way back in 2017. And then you get on probation. You went through JCDI, but you couldn't complete it because of progressive sanctions for continuing to not follow those rules. Then you went to Franklin North, December 7th of 2020. You were on the drug patch program. You did that. You went to anger management. You went through the moral recognition therapy. You were on the high medium caseload. You've been to ISF. And despite all of that, you're still on 2 probations, one of which you could get 20 years in prison and the other 10. You still haven't figured out how to stop using drugs. And you were in fact in a vehicle going to pick up your young children from daycare under the influence of PCP.
Oh, man. However, when I went to Franklin North, it was because I was in a toxic relationship. And that's what they did.
So but here's, okay, how old?
And
How old are you? How old are you?
I'm 42, man.
Okay, so you've been through what appears to be years of drug addiction. And at 42 years old, and you've been on these probations for 5 years or more, you've had every opportunity handed to you to try to help you. And you're still using. So at this time, in cause number 19-32518, I'm going to find counts 1 through 5 true, find sufficient evidence to find you guilty. And at this time, find you guilty of escape while arrested, sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 19-32806, find counts 1 through 5 true, find sufficient evidence to find you guilty, and at this time find you guilty of assault on a peace officer. Sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for the time that you've been in custody that the law gives you the right to receive. And then in cause number 21-36615, also find counts 1 through 5 true, find sufficient evidence to find you guilty, and at this time find you guilty of possession of a controlled substance. Sentence you to a term of 18 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. All of these sentences will run concurrently, which means together at the same time. I'm going to hand you the trial court certification that shows there was no agreement. You do have some rights to appeal. You need to sign that with your attorney, and then I'll give you that copy. Also, I'm handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you, Do you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts? You can talk with Mr. Kimler.
Right here. And what is the statement? And I'll wait on that.
It's saying that you do have a right to appeal, and Mr. Kimler will talk to you about that.
When do you find-
Number 5.
You hand her that one and just the bottom copy off of that one, Mr. Kimler.
when can I find the straight time?
They'll do the judgments today, and it should show up in the computer probably in the next day or two.
It's the jail does not give us any information.
It's well, right now it hasn't been all calculated, so it'll be in the system in the next day or two. Once the clerk, she's in court right now, so she can't do it, but it'll happen the next day or two. Mr. Burbank, you've got Leroy Harris. All right, are you Donnie Smith?
Yes, ma'am.
This is cause number 26 DCCR 0072. Mr. Smith was previously in court, entered a plea of guilty to. Just like that. To the second-degree felony offense of assault on a peace officer. We took that plea, reset the case for sentencing, and then Mr. Smith was not present for sentencing. I issued a bond forfeiture. The pre-sentence report was already done, and he was arrested, and we're back here now. And so I guess a couple of questions. One, Mr. Coleman, is the state still ready to proceed and go forward with sentencing?
We are, Judge, with the understanding that there is no agreement to the type or the length of probation.
Correct. And so the agreement was for a probation, but not agreed as to whether it was a deferred or a straight probation and the length of time on that probation. Have you both had an opportunity to review that pre-sentence report?
Yes, Your Honor.
The state has, Judge.
Any additions or corrections to that report?
None from the defense, Your Honor.
Not from the state, Judge, if we could have just a brief moment, brief argument, please.
Sure. Ms. Holmes, you may proceed.
Yes, Your Honor. And looking at the PSI report, it appears that all of the current pending matters all occurred on the same day, which is out of character, obviously, for Mr. Smith, who has no previous criminal history. He had no previous juvenile history. And so on this day, he was experiencing, he has been diagnosed with a few mental health situations such as bipolar disorder, ADHD. And I think a part of that is why he acted out on this particular day. He is aware that his actions have brought him here, and he is remorseful, and he knows that if given the opportunity on probation, he will abide by the rules and do what needs to be done to successfully complete probation. It's also important to see that they evaluated him at a low risk level, which means they feel that he is a probationer that would benefit from specialized programs with probation, as well as with the mental health services, and they don't feel that he would likely reoffend or be an issue on probation. So I believe that's very important for the court to see. Your Honor, we are asking that due to his lack of criminal history, that he be afforded the opportunity to be placed on deferred probation to show that he can abide by the rules. Obviously, we will be requesting that he be placed on a mental health caseload as well. To aid with that. And also he wants to get his GED. As the court can see, Mr. Smith has an 8th grade education and did not go to high school. And he does want to get his education and get his GED so that he can have gainful employment and help to provide for his family. And Your Honor, we are asking for deferred probation. The length of time, obviously, whatever the court deems necessary, but we do believe that deferred is the best for this situation.
Why didn't you come to court for sentencing?
I didn't have no transportation at the time, and I was sick.
Did you call your
I
bondsman?
called the bondsman. They said there was nothing they could do about it. I tried to get a hold of my lawyer, and she didn't answer. And I called the courthouse, and they said just try to come in later on that day. And I had no transportation. I have transportation now, though.
Mr. Coleman?
State will concede that the defendant has no criminal history. However, I think the problem cause affidavit doesn't do justice in describing what happened there, Judge, between this defendant and Sergeant Noah Visser. This was an all-out fight, Judge, and it went on for some time. This defendant struck Sergeant Visser in the face. It went on, they went to the ground, they went on for about at least a minute until backup units arrived and were able to assist. It's regrettable that I could not get Sergeant Visser here today so that I can enter into evidence and play for you the video of that incident. I suspect that the court would find it very probative as to what you would do. But it was an all-out fight, not like one of these deals where they're just wrestling and tussling and somebody kicks somebody or somebody elbows somebody. This was an all-out fight, Judge. In my opinion, that's what warrants or merits a straight post-conviction probation as opposed to a deferred.
Thank you, Mr. Coleman. I can just tell from the police version in here without seeing the video that this is different than a typical assault on a peace officer that we get where, like Mr. Coleman said, I mean, this, I don't know what was going on, but it also seems like it was very out of character. I agree with Miss Malfina, I mean, Miss Holmes, that something was obviously going on that day. What I'm going to do, Mr. Smith, I'm going to find that you entered your plea of guilty previously, freely and voluntarily. I'm going to find sufficient evidence to find you guilty. I'm going to give you an opportunity today because I'm not going to find you guilty. I'm going to defer all proceedings, but I'm going to place you on probation for 10 years. So I had considered a straight probation with less time, but if I'm going to give you that opportunity for deferred, it's going to be a long probation. If you do everything you're supposed to on this probation, there's no reason you couldn't even get off of it early, but it's going to make sure that we know that everything that you need is getting taken care of. I am going to order that as a $500 fine and order that you follow all of the rules and conditions of probation. That is going to include participating in any mental health care services through Spindletop. If they say you have to do something, even if you don't think you need it, it is now part of your probation. So you're required, if it's medication, if it's counseling, whatever. In addition, I'm going to order that you get your GED. I'm glad that you want to do that. It's not going to be easy since you stopped school so early, but it's still possible. You can do it. And now you're going to be required to do it because it helps everybody if you do that. So I'm going to order that you start that process within 45 days of today. So you don't get to wait and say, well, I've got 10 years to get my GED. I want you to get that GED because it's only going to help you do better in life. If you do everything you're supposed to in this case, this is the best opportunity of your life today to make some real big decisions that change your life because you don't have a felony conviction on your record. And if you're successful, the case will be dismissed at the end. You'll never have a felony conviction.
That's cool.
The other side, it's great because having a felony conviction changes everything. You can't get certain jobs, you can't live certain places, you can't vote, you can't have a firearm. I mean, the list is long on how bad having a felony conviction is. So you've got that opportunity today. If you violate any condition of probation, then you'll be back in here on a motion to revoke your probation. You can be found guilty, which means you'll get the felony conviction. And then I can send you to prison anywhere in that length of time of the punishment range, which is between 2 years and up to 20 years in prison. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Also, I'm sorry.
This.
Let me see the trial court certification. I just need to change the date. I'm gonna handwrite it. Because that's from the other one. Also, I am making a finding. There was a previous bond forfeiture in this case dated April 28th of 2026. All right, you can go back with the bailiff. Good luck to, well, here, let me, hold on. There you go.
Thanks, Judge.
Thank you, Mr. Coleman.